All right, folks, good afternoon. We'll give folks another minute or so before I go ahead and get started. Welcome, happy to have you here. So I will start here in a minute or two. And if you have any questions, feel free to put them in the chat. We will get to questions at the end of the presentation. All right, it is 1:01, so to be respectful of folks' time, I'm going to go ahead and get started. Hi, I am Sky David. I'm the staff attorney here at the Coalition Against Sexual Assault. I do our policy work and represent survivors in campus cases. If you have any questions for me about any of this, my email will be at the end of the presentation. But if you have questions that you'd like for me to address in front of the group, I am happy to do so. You can put it in the chat or just hold your question until the end. So we're going to talk about mandatory reporting, the changes in the law since 2019, and advocate privilege within that change. So if you want to just write down or put in the chat something that you're confused about with the new mandatory reporting law, or something that you would like to understand about the new statutory changes, feel free to do that. I'm going to start just by highlighting the bill and what it does. It does increase prosecutorial options for delayed reports of juveniles or victims of violent offenses, sexual offenses, or child abuse. So if someone doesn't disclose until later in life, it still allows that person to bring a civil case. It does expand the duty to report child abuse. It has a provision for online predators in order to be consistent with the Supreme Court's changes to our child abuse and online predatory law. It does also extend the statute of limitations for civil action for child sexual abuse to age 28. Previously, that was age 21. Requires training related to child sexual abuse and trafficking for school personnel. And that began actually in school year 2020-2021. So we are well underway with that. Closes the incapacitation loophole and closes the withdrawal of consent loophole. So as far as where this bill came from, I should say the original version of the bill, this was passed October 31st, 2019. If you've been on any of my presentations to do with mandatory reporting or incapacitation, consent since then, you've probably heard my spiel about this bill, but the bill originally came from the AG's office, and about 25 to 28 states had similar bills as far as child abuse provisions. Child sexual abuse really stemmed out of the Catholic Church abuse allegations, as well as the Boy Scouts. So the National Group of Attorneys General all got together at their conference, and this is one of the pieces of legislation that just went all over the United States. So that original bill merged with a couple of other bills, which were NC CASA priorities. One of those would have closed the incapacitation loophole, and we'll talk about what that is. One of those closed the withdrawal of consent loophole. During the conference process, so in both state legislatures and in Congress, a bill passes from one chamber to the other, the House to the Senate or the Senate to the House. And if there are no changes made, it can just pass both chambers and go to the governor or to the president. If there are changes, the bill has to go back to the other chamber that previously approved the bill. Let's say, so this bill started in the Senate, made some changes over in the House, and when it went back to the Senate, they voted not to concur with those changes. And then that begins a conference process. In Congress, that's called reconciliation. And that is when there are folks from both the House and the Senate who are appointed to kind of hash out the final details of that bill. We're currently doing that right now with the state budget. So we're in the conference process for that. So the folks that write the budget on the House side and the folks that write the budget on the Senate side are hashing out their differences. But with this bill, we merged some other bills into Senate Bill 199 when that conference process happened. And then when the finalized version comes out, both the folks that are in the House and the Senate sign off on that. And then the bill goes concurrently to both chambers. And there's a final version that you can only vote up or down. You can't amend. So it is easier to put something in a bill there at the end during that conference process and ensure that it's not going to come out of the bill. So that's how we ended up with this conglomerate bill that has tons of implications for sexual violence. We're going to start talking about child sexual abuse and the changes in the bill that are related to that. So there is a new mandatory reporting law to law enforcement for certain crimes involving child victims. So what I want to say is that the child abuse reporting law that everyone is familiar with and has been in law for decades is 7B301. That's your child abuse, neglect, dependency, and maltreatment. That is its own law. And that is for abuse, neglect, dependency of a child by a caretaker or guardian or custodian. So you have that law over here. This is a new parallel law. So you still have to report those crimes, abuse, neglect, dependency of like a parent abusing a child. And that goes to the Department of Social Services. On this side, this new law is for sexual offenses, sexually violent offenses, and bodily injury, serious bodily injury, and that is by anyone. Again, by anyone, doesn't have to be a caretaker or a parent. And as you can see in the title here, that is a report to law enforcement. So over here, report to DSS, abuse, neglect, dependency. Over here, law enforcement. Now, what I will say is that both of these laws have parallel reports. So let's say you're not thinking about, oh, does this need to go to DSS or law enforcement? You call law enforcement, they have to report that to DSS. So I would not focus on where you need to make that report to. Just know that these are both separate reporting laws. So what the new law specifically says, any person 18 or older who knows or should have reasonably known that a juvenile has been or is the victim of a violent offense, sexual offense, or misdemeanor child abuse under GS 14-318.2. And you're like, I don't know what 14-318.2 is. It's this law. So that will be fleshed out, and we'll send out the materials afterwards that state exactly what crimes are covered under that. Shall immediately report the case of the juvenile to the appropriate local law enforcement agency in the county where the juvenile resides or is found. Again, this is the definition. I will note the differences between this law and 7B301, abuse, neglect, dependency, later on in the presentation. So we'll kind of go through what those specific differences are. So as far as what a report looks like, what are the reporting details? Reports can be made orally or by telephone. And I will note that in 7B301, that's orally, in writing, or by telephone. So the in writing portion of this has been removed. And you can see here that the report shall include information as is known. You have all of these things like where is the child, the address, the name and address of their parent or guardian. Basically, it's telling you here, you need to give them as much information as possible. What is a juvenile under this definition? So, person younger than 18, not married, not emancipated, or a member of the armed forces. And the definition here specifically states, for the purposes of this section, the age of the juvenile at the time of the abuse or offense governs. So you can read this next paragraph that says, if you're just reading this straightforward, that is going to include adults who had been a victim that occurred when they were under the age of 18. I think this is not what was intended in the bill. So if someone reports to you at age 25 that they were abused as a minor, that technically this reading would make that a mandatory report. However, and this is a big however, this bill did not go into effect until December 1st, 2019, and it only applies to offenses that happened on or after December 1st, 2019. Again, this bill did not go into effect until December 1st, 2019, and only applies to offenses that occurred on or after that date. What does that mean? It means that there is really a small period of time that we're still in where someone was a minor and December 1st, 2019, and they're an adult now. If they were to report that, I still think this needs a technical correction for the bill so that we don't create a bunch of reports when people are adults and there is no child in harm. The purpose of this saying that the age of the juvenile, the time of the abuse or offense governs, would be because we're expecting people to immediately report, and hopefully there was an immediate disclosure. We all know that that does not happen, and does not happen as often as one might think. However, the purpose of the bill was to ensure that if there are other juveniles or other minors in the home, that those folks are not in danger's way. So this is something that could change in the future, but as of right now, this is what we have. What offenses are reportable? 3 types of offenses. A violent offense. So that's any offense that inflicts on a juvenile any pain other than non-accidental means, a serious bodily injury, substantial risk of death, or causes serious permanent disfigurement, coma, hospitalization, protracted condition causing extreme pain or loss, or serious physical injury. And that includes serious mental injury and also includes attempt, solicitation, or conspiracy to commit or aid and abet any of those offenses. And you'll see these statutory citations here are again from the bill and are all included in the materials we will send out. Misdemeanor child abuse is the 3rd offense here. So that is when a parent or person providing care or supervision to a child who is 15 or younger inflicts or allows to be inflicted physical injury by non-accidental means or creates or allows to be created substantial risk of physical injury or a sexual offense. So the bill does say that it includes sexually violent offenses. There's some bill drafting in this that is also a little confusing, but I will say that it covers really anything you would think of as a sexual offense, whether that's rape, sexual activity, sexual battery, human trafficking, pretty much anything that you would think of as a sexual offense, it's covered in this bill. And here's where I referenced that bill drafting error. there is this definition of sexually violent offense, but the remainder of the bill refers to sexual offenses and does not refer back to a sexually violent offense. I think this was just a bill drafting error, and it includes all sexual offenses. So some changes in obligations to make reports. The obligation to make a report to a county DSS of suspected child abuse, neglect, or dependency. Again, that's separate and independent from this obligation to make a report to your local law enforcement agency. Two parallel laws, you're going to hear me say it 100 times. Depending on the facts, a report will be need to be made either to DSS, abuse, neglect, dependency, law enforcement, if there's a designated crime here, but there isn't that child abuse, neglect, or dependency, or both. Again, they will reference one another. Within 48 hours, one office has to make that referral to the other, whether it's DSS and law enforcement or law enforcement to DSS. But they are different. Additionally, just to note, law enforcement officers are mandated reporters under both laws. I'm going to pause here for a second. For abuse, neglect, and dependency, everyone is a mandated reporter. We're all mandated reporters of abuse, neglect, dependency. There are some exceptions in this bill, and we'll get to those as well. But law enforcement, not accepted under either bill. So should a report to law enforcement be made and that law enforcement officer finds evidence of abuse, neglect, or dependency, they have to make an oral and subsequent written report to DSS. And here you'll see it going the opposite way. If DSS finds information, they have to make an immediate oral and subsequent written report to the DA and to law enforcement. So you can see how this is going to flow both ways. So reporting facts, there's no change here as far as sharing information about who the reporter is. If you are calling to make a report of abuse, neglect, dependency, and or of child sexual abuse. In this, the reporter's information is not going to be disclosed unless there is a need for that name to be released to carry out mandated responsibilities. Other than that, without a court order, the reporter is going to be protected. Immunity. I will note here, a mandated reporter who makes a good faith report and cooperates with law enforcement or testifies in a judicial proceeding is immune from any civil or criminal liability arising under state law. So as long as you're making a report in good faith, you're going to be protected by the law. And this is what I tell folks when they call me and they're not sure whether or not they need to make a report. If you're not sure, you might as well make a report and protect a child and rather than put someone in danger. Like I said, there are some exceptions to this new mandated reporting law. As you can see, it is a universal mandate and applies to all adults who are 18 and older. But there are some folks that are exempted. 1, attorneys. 2, licensed psychologists, associates, and employees. 3, licensed or certified social workers engaged in private social work services. So if you're a social worker in a school, you're not exempted. Private social work services. 4, licensed professional counselor. And 5, agents of rape crisis centers and domestic violence programs. No one else is exempted from mandated reporting under this law. I will note that since this law passed in 2019, there have been some other folks that would like to be exempted. And in 2020, 2020, psychiatrists were included in a bill to be exempted, but that bill was subsequently vetoed by the governor, and they were not, it was not overridden, and so they are currently still not exempted. So this is just kind of that easier list to look at of those folks that are exempted. Again, for 7B301, abuse, neglect, dependency, no one is exempted. But from this new law, because of the nature of sexual abuse coming up, these folks are exempted. Like I said, there are some folks that would like to be exempted from this. It includes SANE nurses, psychiatrists, and marriage and family therapists. Also within the bill, there is a brand new statute on failure to report. And that applies to both 7B301 and 14-318. A mandated reporter who knowingly or willfully fails to report or prevents another person from reporting is guilty of a Class 1 misdemeanor. So this means if you prevent someone else from reporting child abuse, neglect, dependency, and or child sexual abuse, you can be faced with a Class 1 misdemeanor. That usually does not come with jail time. It's just a fine. However, it is something that district attorneys were looking for to kind of just have another tool in their toolbox. And again, this law stemmed from the Catholic Church and Boy Scouts, Boy Scouts. So in order to hold those folks accountable, it's just an added layer of protection here. I covered some of the reporting facts, what needed to be disclosed, which is really just as much information as you know. That's the information you should give to law enforcement. This also includes that law enforcement should keep all of that information in strictest confidence, and that includes that reporter's identity. Maintaining the confidentiality of the reporter's identity serves the purpose of the reporting law to encourage the reporting of suspected abuse, neglect, or dependency. But just like with all confidentiality, there are occasions where maybe your reporter's name needs to come out, and in those cases, a court order will be sufficient. So this is going to compare the two mandatory reporting laws. On your left is going to be abuse, neglect, dependency, and on the right is the new mandatory reporting law. So who is obligated to report abuse, neglect, dependency? Any person or institution. On the right, any adult 18 or older. So you can see the differences here that the institutions, your church, your school, whatever that may be, they are also mandated reporters under abuse, neglect, dependency, but the impetus lies with the person in 14-318. Exemptions, you can see on the left, it's just your attorney-client privilege, and on the right, the exemptions that we talked about. The standard for reporting for abuse, neglect, dependency, that is a cause to suspect. And what does a cause to suspect mean? It means what you think it means. You have a suspicion. And in the new reporting law, it is known or should have known. So actual knowledge in those cases. And who qualifies? They are the same in both laws. Juvenile, not emancipated, not married, or in the armed forces. And then on the right, I do include that age of the juvenile at the time of the abuse governs. What abuse, neglect, dependency, you've heard me say that a bunch of times. And in the new mandatory reporting law, that has been or is the victim of a violent offense, sexual offense, or misdemeanor child abuse. and the report is made to, again, you've heard this a few times today already, for abuse, neglect, dependency, that report is made to the Department of Social Services. For violent offenses, sexual offenses, or misdemeanor child abuse, that is made to law enforcement. When does that report have to be made by? So interestingly enough, for abuse, neglect, dependency, it does not specify. And in the new mandated reporting law, it says shall immediately report. In abuse, neglect, dependency, it just says shall report. So there is that immediacy that is included in this law, but I think is assumed in abuse, neglect, dependency. And how to make a report for abuse, neglect, dependency, that's orally, by telephone, or in writing. Literally any way you can make that report is sufficient. And for the new mandated reporting law, orally or by telephone. Information to include, generally they're going to be very similar. As much information as you have, they're going to want that. The reporter identity information, reporter must give their name, address, and telephone number, but refusal to do so is not going to stop an investigation. That refusal to do so portion is not included in 14-318, but again would be assumed, and identity is protected and may only be disclosed under different criteria. Like I noted earlier, there is going to be that good faith immunity that is included in both laws, and a violation, this is a new law for both 7B301 and 14-318.6, that knowingly or willfully failing to report or preventing another person, again, for both of those, that's a class 1 misdemeanor. Again, class 1 misdemeanor. And the statute of limitations for both of these amended in this law is 10-year statute of limitations. Some of these were previously 2-year statute of limitations. Also in the bill, the civil statute of limitations has been extended for child sexual abuse. So victims have until age 28 to commence an action. So if it is a felony level crime, there is no statute of limitations for felonies in North Carolina. But if it is a civil claim for a misdemeanor, that now has an extra 7 years because it was previously 3 years after the juvenile turns 20 or turns 18, so 21, and now it is age 28. We have seen since December 1st, 2019, that there have been 14 cases filed since this law went into place. So there were some fears from legislators that this would clog up the court system and there were just going to be a flurry of civil actions, and that has just not been true. So we think that maybe the age here will be raised a little bit more in coming years. So here is a flow chart, and I'm actually going to show you this in another way. Okay, so this is a little flow chart that is just going to show you whether or not you need to make a report under this new law. And it also includes 7B301, so abuse, neglect, dependency. So you can see here, like, are you covered by a privilege? You'll kind of just flow through that. And then the second page of this is including what is included under 7B301. So who is an abused juvenile? Who is a caretaker custodian? And what is dependency and neglect? So that's under 7B301. And then the next page of this includes the specific definitions for the new mandated reporting law. So bodily injury, physical injury, and sexually violent offense. Also includes what all of those sexual offenses are. At the bottom, it includes violent offenses. And then who is privileged under the new mandatory reporting law. So folks that do not have to report. And so this will be sent out after the presentation, but it really just gives you kind of both laws, that flow chart to flow you through it, and then all of the definitions. You can just have a handy guide to be able to look at that as needed. Let me switch back. I think folks have found this flowchart helpful, and it has, again, all of that information that you might need as you're moving through whether or not this is a mandated report under 7301 or under 14-318.6. So, like I said, there is no statute of limitations for felonies in North Carolina, but the current statute of limitations for misdemeanors was only 2 years. So this changes the statute of limitations for the following offenses to 10 years, from 2 years to 10 years for failure to report, sexual battery, indecent liberties between children, misdemeanor child abuse, and failure to report crimes against juveniles. Hold on just a second. Sorry, folks. Okay. So all of these change from a 2 to 10 year report. The new law does clarify who a high-risk sex offender is, and it makes it unlawful for a high-risk, sex offender to do any of the following online: communicate with a person that the offender believes is under 16, contact a person the offender believes is under 16, pose falsely as a person under 16 with the intent to commit an unlawful sex act, to use a website to gather information about the person the offender believes is under 16, or use a commercial social networking website in violation of a policy posted. So this stems from a Supreme Court case that said that the North Carolina law for high-risk sex offenders was too broad. So you can see here that it is very specific. It's much more narrowly written to ensure the safety of our children, and also that those folks don't have access to children of North Carolina. Some other changes that were in this bill: date rape, drugging, drink changes. It updated GS 14-401.11, which makes it illegal to distribute food that contains anything that could be injurious to a person's health, to also include beverages. Pretty wild that until 2019, we only had a law that said you could not drug food, essentially, which was what we called the Halloween candy statute, to also include beverages. And that's something that Incapacitation had been working on for decades, to not be able to drug drinks. But this will hold folks who drug a drink in order to have the intent to sexually assault could be liable. Another big change in this bill that we're now a year and a half into is that it closed that consent loophole for withdrawal of consent, brought us up to speed with the other 49 states in the United States to allow that someone could withdraw consent at any time during a sexual act. Incapacitation. This came out of a 2008 Court of Appeals case, State v. Haddock in North Carolina, that said that in order to be mentally incapacitated, someone had to do an act to you, like they gave you the drug without your knowledge. But now it states that a victim, due to any act, is substantially incapable of either appraising the nature of the conduct or resisting the act of intercourse or sexual acts. So you took the drugs yourself, you drank the drinks yourself, and that is how you became incapacitated. Now we can still go ahead and charge that offender with a rape. I will note that both of those, consent and incapacitation, were NC CASA priorities. Also in this bill, I mentioned this at the beginning, it did require that local boards of education and charter schools adopt a sex trafficking training program for school personnel. And it also includes all sex acts, not just sex trafficking. And that began in 2020 for the beginning of the school year. So I do want to note here that if you have any problems with mandated reporting or something that is not included, please let me know. Like I said, there were a couple technical changes that needed to be made to the bill. You've heard me talk about a few of them, one of them being later disclosures after someone becomes an adult. I think that's something that we're going to run into as the years progress. But if you have anything else that you see as an issue, please let me know. Here is my email. It's Skye, S-K-Y-E, at NCCASA, and we will open it up for questions. I see, okay, there is a question. As an agent of an RCC, it seems like one law requires me to report sexual abuse, no exceptions. In the other states, I am exempt. How do you reconcile these? Okay, great question. As an exempt party, why would I not report child sexual abuse? So for the first law, that is for abuse, child abuse, neglect, dependency by a parent. And due to the nature of our work, I think that the exemption for RCCs is so that someone can decide to disclose to a counselor or an agent of a rape crisis center and feel that they have that confidentiality. But for abuse, neglect, and dependency, when that child is endangered day after day with that caretaker or parent or guardian, no one is exempt from that because they are in immediate danger at all times. Other questions?
I have a question. Can you hear me?
Yeah, go ahead.
I do supervised visitation. I'm a program manager of supervised visits. And we have a client that they've been coming for well over a year now. The child had beautiful hair, and now all of a sudden she doesn't have any at all. It just started falling out. And when we asked the father who has custody, he's an oncologist. He happens to be an oncologist. And we asked him, you know, is she going to be all right? You know, does she have alopecia, anything like that? And he said, no. He took her to an endocrinologist, and it's about her diet and stress. So she's 12 years old. She lost weight. She looks great, but her hair is still bald. And we sort of think that he's doing something to her in order to try and keep her with him and not give her to the mother. And she has two other siblings. One sibling lives with the mother. The mother has supervised visitations with us. So we just feel like there's something else going on there, because she just looks totally healthy and she has no hair.
So are you asking me if you could make a report?
Yes, we've been, going back and forth with this about, both parents seem to be, you know, nice, you know, but the mother's boyfriend shot the father, but he still lived. The boyfriend's in jail. But when the family comes together for visitations, they all do well in the visits, but they have that underlying factor going on there. We don't know if the mother's going to ever be convicted of anything, because she had to tell the boyfriend where to find him to shoot the father. So, um, so the father still has custody of his son, who is now 19. The son won't leave his sister by herself with the father to go to the mother. So, and the child is about 12 years old. So we're worried about her, that he's giving her something to keep her hair from growing, with him being an oncologist. And we don't know whether we should be reporting this or what.
So under 7B301, that's abuse, neglect, or dependency, it would appear that this would fall under 7B301. And all you need in order to report that is a cause to suspect that something is happening. And based on the information you just gave, there's plenty of cause to suspect, the older brother doesn't want to leave the younger sister, the hair, that gives you enough to be able to make that report in good faith. And it would feel like this would be a pretty easy report to make and feel justified in making that report under 7B301.
7B301?
Yes, ma'am.
Okay. All right. Thank you for that, because we've been, pondering this for such a long time, and something's just not right about that.
Yeah, all you need is that cause, like that suspicion that something is happening, and you surely have that.
Do I have to state who I am? Do I have to report? Can I do this anonymously?
You can give your name, address, and information, but failure to do so does not stop them from doing a full investigation. So if you report it anonymously, they're going to have to go ahead and do the investigation. So it's really one of those things that's up to you.
Okay. All right. Thank you.
You're welcome. So Rebecca also said, so the spirit of the exemption is to allow me as an RCC agent or counselor not to report past child sexual abuse of a current adult. That's right. And if someone is still in danger, we do encourage that you go ahead and report if there is a minor who could be in danger of child sexual abuse or any other type of violent offense. Yeah, thank you for the questions. Anyone else with questions about either of these two laws? And like I said, we will send out that flow chart in the slides from today, so you can take a look at that and compare the two statutes. It can be confusing. I don't see any other questions right now, but we will hang out here for a few more minutes. If you have a question, or if you have something you want to ask me and you don't want that to be in front of the group, feel free to shoot me an email. It's sky@ncasa. I think Alexandra put that in the chat, or you can give me a call as well. I take calls on mandated reporting quite often. And so I'm happy to talk you through the process, or shoot me an email and we can talk about it there as well.
I think you did a wonderful job in your presentation. It was, so helpful and meaningful. And I'm going to take this back to my staff.
Great. Thank you so much for coming.